Hello and welcome to Newsclick. Supreme Court in a landmark judgment struck down Section 66A of the IT Act, which provided provisions for the arrest of those who posted allegedly offensive content on the internet, upholding freedom of expression. Today, to discuss the issue and the judgment, we have with us Rishab Bailey, Director Legal, Society for Knowledge Commons. Hello Rishab, welcome to Newsclick. Rishab, first of all, what was Section 66A? And what were the problems with it?
Section 66A penalized, as you mentioned, the sending of certain offensive messages in the context of the internet. So basically, it said that any information that is grossly offensive and menacing, or information that is annoying, inconveniencing, could be taken down, or you could proceed against the person sending such information. Now, over the last couple of years, we've had lots and lots of instances where the police has used this provision to arrest people for posting fairly innocuous messages. You must be aware of the many instances of this. You had the two girls in Palghar who posted a comment following Bal Thackeray's death who were arrested, their house was vandalized and so on. We've had a professor at Jadavpur University who emailed a cartoon of Mamata Banerjee, I think, and was arrested for that. So we've had lots of these kind of instances, particularly of a political nature. So the question being asked was whether the provision itself is arbitrary or it lends itself to arbitrary application, and whether it's overly broad, since it seemed that there were a lot of crimes that were essentially innocuous bits of behavior that were being penalized. So what the court has done, it has examined Section 66A against the principles of constitutionality, I mean particularly on the basis of whether it falls under the reasonable restrictions under Article 19(2) of our Constitution, and has found that the provision is actually unconstitutional. So what it has actually said is that what the court has said is that while the internet is a different medium to your traditional media, for instance, and therefore you can have different regulatory systems to govern traditional media and the internet, however, these restrictions, even in the context of the internet, must fall within Article 92. That means they must fall within one of the 8 subheadings within 92, that is in the interests of sovereignty of India, national defense, so on and so forth, or else, they must have they must be reasonable in nature. So the court found that the terms used in Section 66A were incredibly wide and ambiguous, and they brought within its content.
Exactly, this is the point. All those words were very vague. So how do you define what is going to be offensive now and what is not going to be offensive?
Absolutely. So that's pretty much one of the reasons why the court found that it was unfair to expect either the authorities to enforce such a provision properly, because these terms could not be defined, and plus citizens wouldn't know what offences they could actually be held guilty for. So it actually said that in the case of a criminal statute, you must ensure that the statute is extremely carefully and narrowly drafted, and it is precise in nature so that people are aware of what a crime is and what a crime isn't, or what acts constitute a crime. Even though the government actually said that it will use forbearance in the application of this section, and they said that, don't strike down the provision, we'll just ensure that people are not arrested willy-nilly as they have been in the past. The Supreme Court refused to take this on board and actually did point out that a law is a law, and the government assurance will not bind another government in the future. And so therefore the fact that the law is unconstitutional means it has to strike it down per se. Importantly, the court also actually noted the fact that there is a need to understand that unpopular views themselves are not illegal. Just sending something that is unpopular cannot and should not be stifled in a democracy. The court actually, it's an important distinction, noted the difference between inciting an offence and just advocacy of certain claims, and actually talked about how the advocacy is perfectly okay. It's only incitement that is actually a problem.
So, what after the judgment should we expect? All those people who have posted some content, should they be scared of getting arrested now, or what are the limitations of it now? How is the government
What this actually means is that the very specific criminal acts that were prescribed under 66A are no longer offences. So even the pending cases under 66A will no longer exist, because 66A is no longer on the statute book, since it's now considered unconstitutional. However, that doesn't mean that other laws such as the IPC and so on will not apply in the context of the internet. And don't forget, the IT Act still has various other penal provisions as well, whether you talk about 67, 66B and so on and so forth, which penalize various other kinds of behavior, whether it's obscene, content, so on and so forth. So, as I said, you will still have to be careful that content that falls foul of provisions in the IPC, for instance, causing hatred between religions and so on and so forth, is not posted online, because you can still be proceeded against under other laws. It's just that this one particular provision, which talks of annoyance, inconvenience, so on and so forth, has been struck down.
And why at first in 2008 was the law actually brought into the course?
Actually, that's an interesting question. Law was actually, if you look at the objects and if you go back to the debates that were carried out at the time when the bill was passed in 2008, first it's relevant to actually note that the bill was passed in a huge hurry. There wasn't actually much discussion on this. It was passed on the last day of Parliament, of the parliamentary session in 2008, and with barely any discussion on the provisions of an act which is actually vitally important for our economy and for our society, given how we are moving towards an internet society. That said, basically, the provision was supposed to only deal with spam, which has proven to be a problem in the context of the internet. I mean, it takes up a lot of bandwidth, it's annoying, so on and so forth. However, what happened was that it became a sort of broad catch-all provision, which was then used by the police to, in a sense, almost terrorize innocent people. And which is what the Supreme Court has taken cognizance of and stepped in to say that this cannot be done. It has to be a more specifically worded section which criminalizes certain behavior in the context of the internet.
So what does the judgment have for the common people? For example, even now we were just going through the news that a couple going on a trip to Goa was continuously being, their activities were being tracked through Facebook, and now they have been fined for some indecent pictures that they have posted. So, I mean, how do you define indecency, or how does all these things come into the judgment?
See, as I mentioned previously, acts that are criminal offences under various other laws, whether it's the IPC, whether it's even laws such as the Prevention of Insults to National Emblems Act and so on and so forth, will continue to be crimes because they have not been looked at by the Supreme Court in this particular instance. So those crimes, if committed on the internet, can be proceeded against. So given that our IPC, for instance, prescribes the distribution of obscene content or obscene material, such a ban could also apply in the context of the internet. So in this situation, if you have the supposed spreading of obscene content on the internet, yes, action could be taken on those grounds under the IPC itself. However, 66A will not apply. And why that's important actually is that the IPC has various checks and balances built into the system, given again that it's an old legislation which has been there for many years, which were not there under the IT Act. So therefore, it's particularly important because now a person need not necessarily just be arrested, for instance, and so on.
So if we talk about 66A and the incidents that have been followed with the section, is that politicians have been misusing it, be it Azam Khan or be it in West Bengal or be it in Maharashtra or anywhere. So I mean, what you said, if not 66, since 66A has been removed from it, but there are other laws. So for a common man, he should still be scared of being trapped into all these things, of posting something and getting arrested for some other IPC included into it for some other section?
Well, if you have committed a criminal act in the context of the internet, just the fact that it's the internet is not going to save you from punishment. I mean, so if it's a criminal act per se, which would be treated as such in the physical world also, it will be treated as such in the online world. However, what the difference I'm trying to bring out is that 66A was incredibly broad and ambiguous, as you mentioned previously as well, that it's worded very, very widely. So you could bring within its ambit a huge number of offences that were not or would not normally be considered offensive. Bring under its ambit acts that would not normally or reasonably be considered offensive, which is why it was prone to misuse. In the case of the IPC and the various other crimes that you're referring to, the hope is, I'm not saying that they cannot be misused, the chances of misuse are less, again, because of the fact that there's more clarity about how these provisions have to be defined and also in terms of the procedures leading up to arrest.
And further, how do you think is the BJP government going to react to it, keeping in mind that they have been very particular about what is being posted and not? So how do you think is the...
Well, no political party can afford to say that the Supreme Court judgment is either is actually wrong or anything of the sort. None of them in today's times can afford to appear as though they are in favor of punishing people so harshly for such innocuous activities in the context of the internet. So all political parties across the board, as you've seen in the newspapers today or in the media today, have broadly come out and supported this decision of the Supreme Court. What's interesting though is the fact that firstly, the bill was pushed through, or the section was included by the Congress government, despite humongous amount of pressure on them, protests, so on and so forth over the last few years. They failed to take any action, and even their submissions before the court appear to be along the lines of you should keep this provision on the statute book because we need some measures so as to be able to prevent certain types of activity on the internet, since more and more people are using the internet and so on. Various people from the right wing have sort of expressed their doubts about whether now certain types of activity will be, or whether the more liberal mindset will sort of find it easier to express itself online, and whether that's good or bad. And but I think the court has made it very, very clear that any restrictions on speech have to be within the context of 19.2, and therefore even any new law that is drafted by the government to replace 66A will have to pass the test of 19.2. And so that's some cheer you can take from the judgment as well, even in the context of any future law that may come into place to replace the existing 66A, or the now defunct 66A.
In the judgment, Rishab, it has found 69A constitutional and has read down section 79. So what does this mean and what are its implications?
Okay, 69A and 79 are two different provisions, but they are vaguely connected, and I'll explain to you how. 69A pertains to how information should be blocked on the internet. Now, the court basically found, or it went into the various safeguards that have been established and the conditions for exercising this power that the government has, and found that there are various safeguards in the provision, and therefore felt that since an opportunity, there's multiple levels of decision making on the need to ban something on the internet, so on and so forth, it felt that it was generally within the ambit of the Constitution to give the government such a power. However, it's interesting that the court has not actually looked at the issue of public order in the context of as a precondition for something to be banned in the internet. It has looked at public order in the context of Article 19 or in the context of Section 66A, sorry, but not in the context of 69A, which I think is actually troublesome, particularly because in the PUCL case, which was decided in the last decade in 1997, which pertained to tapping and surveillance, in that case the court actually noted that the public order clause in the Telegraph Act acted as a fetter on arbitrary exercise of surveillance powers by the government. So similarly, one could argue that having a public order clause in Section 69A is essential to ensure that the government only acts to ban material which has a direct and immediate effect to ensure that public order is not maintained or the tranquility of society is not maintained. So this is, I think, something that the court could have actually looked at further. Secondly, when you come to Section 79, Section 79 essentially is an exemption provision. What it says is that an intermediary will not be liable for content that they have posted online if it turns out that they have followed certain due diligence criteria and so on and so forth. If they have not hosted, created, edited the content, in addition to which they followed certain due diligence criteria. The diligence criteria included, amongst other things, that if they know that certain content is illegal, breaches various terms that were prescribed under the rules, in that case it should act to take out the information immediately. Now, the court actually strangely found that this provision it didn't go into the constitutionality of this as it did with 66A, which I suspect it should have, but read down the provision, which means it has interpreted it narrowly in order to say that henceforth intermediaries will only have to take down content if either they receive a court order or if they receive a notification from the government under Section 69A. Earlier, under Section 79, any person from the public, any affected person, could complain to an intermediary saying, please take down this information because it breaches one of these conditions that are mentioned in the section. And interestingly, that section, or the rules also, they prescribe things such as blasphemy, which are not crimes in India. So I'm very surprised actually that the Supreme Court didn't look into these rules in greater detail and look into the constitutionality of these rules in the first place. So overall, while the Supreme Court has actually taken cognizance of the fact that you cannot have intermediaries being an adjudicatory party. I mean, intermediaries cannot decide whether something is legal or illegal and act to take it down, and that this could have negative consequences on free speech and so on. The compromise the court has arrived at appears to me a little shoddy, or it is sort of ill thought out, because clearly there's a problem with the way the Act itself has been created, in that it sets up two methods of blocking information, one under 69A and one under 79. And so it's tried to bring these two provisions together, but I don't think it's done it very successfully.
So let's hope, Rishab, with the removal of Section 66A, there will be some space for expression on the internet and there won't be any other means to curb this freedom. We'll be coming back to you over such issues. Thank you.
Great to be here.